The next case to come before the court is Robert Kehoe versus Stanley Aronson et al. Each party will have up to 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. Should you like to reserve time for rebuttal, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please stand behind the podium, introduce yourselves, keep your voices up. You should not use the names of minors or children or victims, should that be relevant to your argument, and you can refer to those folks by their initials or general terms. The judges have read your briefs and we're ready to proceed when you are, and I would just ask the appellant, would you like to reserve time for rebuttal?
Yes, Your Honor. 3 minutes, please.
3 minutes. Okay, then you may proceed when you are ready.
Thank you, Your Honor. Good morning. May it please the court, counsel, I'm Robert Kehoe, and it's my privilege to appear before you this morning pro se. This is an abuse of process case. The sole assignment of error before the court is whether the trial court erred in granting summary judgment on the second element of an abuse of process claim, finding that there was no issue of fact about whether the defendant used legal process for the ulterior purpose to gain a collateral advantage or obtain relief that the court could not otherwise order. Briefly, by way of background, this case arises out of the conversion of enclave cooperative housing to the condominium form of ownership. There were at least 4 individuals that opposed that conversion and decided not to pay their community association dues in protest. Eventually they were sued by the Enclave Community Association and they were represented by the defendant, Stan Aronson. One of those defendants was Stan Aronson's daughter, Beth. What followed was a series of claims made by defendant Aronson against a number of parties, and at this point it's important for the court to understand the scorecard, because the analysis has to be of the proceedings, and the question is, what were the proceedings against me and my law firm versus the proceedings that defendant Aronson brought against third parties who were not yet in the case versus the Enclave Community Association, which I subsequently no longer represented. So at that point, the defendant was making claims against the conversion consultant, ROA Hutton, who had not previously been a party to the case. I never represented Hutton, and I had no control over Hutton. After about 6 weeks, when the claims had been made against me, I was put in a position where I had to resign as counsel because of an obvious conflict. At that point, the claims that had been made against me were not made against successor counsel, even though successor counsel continued with the collection actions. There were other complaints about formation that preceded my involvement. There was no claim made against predecessor counsel. The claim made against the Enclave, my former client, was for a waiver of monthly community association dues. The claim that was made against Hutton was for a waiver of the conversion fee, which ranged between $4,600 and $6,000. What happened at that point was Mr. Aronson continued to use the legal process to leverage me and my law firm to achieve an outcome for him and his clients that was not otherwise available. Specifically, he attempted to rehabilitate his daughter's reputation. He had fear that because she was sued for not paying her debts, that she would be considered delinquent, and if she chose to run for office or otherwise seek a judicial appointment as a lawyer herself, that somehow that would haunt her. He also looked for assistance in having me obtain financing for her because she did not qualify through Hutton and the conversion process she went to outside third parties, specifically GMAC Financing, and Mr. Aronson expected me to rehabilitate his daughter's credit and obtain financing for her through GMAC. Those are four of the major behaviors or ulterior purposes that Mr. Aronson had after we withdrew from the case and no longer had ability to exercise any control over Enclave as a client, and we never had any control over Hutton or GMAC.
So, counsel, if I understand you correctly, you're saying that the ulterior motive was to use the legal process to leverage you to rehabilitate his daughter's reputation? Is that the specific
That is one.
evidence that you would point to in the record?
I'm sorry?
And that's what we're going to find in the record?
Yes, you will find that in the record in several places, but that is only one of 3 or 4. The major relief that he thought he could obtain through me, the collateral advantage that was not available to the other members of the Enclave Community Association, that he attempted to achieve for his clients, DeCuster, Campbell, Davies, and his daughter Beth Aronson, were a waiver of monthly fees and a waiver of the conversion fee, which I had no ability to deliver, and which the trial court, frankly, had no ability to deliver as against me or my law firm. So in looking at the proceedings, I think it's really important for the court to understand that the court, in the trial court's decision, points to the fact that anything that happens within the proceedings is fair game. It doesn't matter if it's frivolous conduct, doesn't matter if it's unethical. The only thing that matters is you use that proceeding to achieve a settlement. I would submit to you that that in and of itself is an improper purpose, and that the authority relied upon, the 2 4th District cases, really are not the mainstream. The standard of within the proceeding or not does not come from the Yaklovich or the Robb decisions of the Supreme Court. There's a specific decision, the Blank versus Securex case from the 8th District, that says inside the proceeding, that is not proper. But inside the proceeding, Aronson made claims against me and my law firm. I'm not here complaining that he leveraged me for a settlement. I'm here saying that the abusive process was that I did not control the Enclave. I could not deliver that outcome. I didn't represent the client, and even if I did, it would be unethical for me to place his 4 clients over the other 106 residents at the Enclave. More importantly, Hutton was not even in the case. That was not part of the proceeding when I was being leveraged to negotiate a waiver of the conversion fee for Aronson's 4 clients with somebody, R.O.A. Hutton, who was not even in the case. They were eventually brought into the case. I could not obtain financing from GMAC. They weren't even in the case, and they were never in the case. That is the abusive process. That is the ulterior purpose, to obtain a collateral advantage that I could not deliver and the court could not deliver. The court could award money damages against me for the 4 claims that were made against me. If there was liability for negligence or conversion or Fair Debt Collection Practices Act, that would be within the proceeding, and I'm not here complaining about that. The trial court could not order me to pay damages for the Enclave. The trial court could not order me to get a waiver of the fee from Hutton. I had no contractual relationship. I had no client relationship. I had no ability to deliver that result, and the trial court had no ability to make me deliver that result. That is where the trial court erred in finding that the behavior had to occur outside the proceedings. The error there is twofold. One, inside the proceedings, you can still abuse process if you use it for the ulterior purpose of gaining a collateral advantage. The trial court said that everything, the only way to make a successful abusive process claim was outside the proceedings. I submit to the court that the leverage or the club that was being used with me by the defendant was outside the proceedings as far as Hutton is concerned, as far as GMAC is concerned, and at the point in time in the process when I was being leveraged with my former client, that was outside the proceeding. The only thing at that point that was within the proceeding were the claims that were made against me. They were eventually dismissed. Let's talk for a minute about the standard that the court applied. The court looked to the Aronson versus Lucas and Clearmont environmental cases, and it also quotes from the Tomlinson versus AT&T case. I would submit to the court that the holding from Tomlinson was misinterpreted. The holding in Tomlinson doesn't say that it has to happen outside the proceedings. It says that it has been interpreted that way. The Yaklovich Supreme Court case, the Seminole case, and the Robb case that comes 2 years later do not talk about inside or outside the proceedings. There is a patina that is put on the second element of the Yaklovich test by the trial court in this case that bears no relationship to Yaklovich, Robb, or their progeny. The relief that was sought, in addition to my inability to give it, is precluded by statute. So the trial court takes the position that even if it makes the wrong decision and goes up on appeal in reverse for purposes of an abusive process claim, that is appropriate. Let's hope not. Let's hope that what the trial court posits is the position that for abusive process purposes, the trial court can make any decision against anyone, and even if it goes up on the Court of Appeals, it's appropriate to block an abusive process claim. Translation, that means there never can be a successful abusive process claim. If the court can order anything, legal or not, then there can never be an abusive process claim. That is relevant in this case because we have the condominium statute, Title 5311, that sets forth the rights and relationships between the parties. What that does is it requires people to pay their bills. So the collateral advantage, one party over the other, is if you say to this group, you've used the process to avoid your statutory obligation to pay, then what happens to the other owners? They have to subsidize. It is true the trial court could say under the statute you don't have to pay, but you do have to pay. The court could say, well, you have damages because you delayed the maintenance of the property, etc., and you can get money damages for that, but you can't avoid your statutory obligations to pay. Looking at the time, I would ask the court if they have any questions. If not, I would submit that the trial court erred factually in not understanding which proceedings were happening inside and outside. What got blurred were the various claims, and I will admit, you need a scorecard or a diagram to figure out claims under the association documents, the statutes, the conversion documents, claims against the individuals for non-payment, counterclaim, third-party complaint, new party practice. But that all got blurred, and the only claims and the only part of the trial court's decision that would make sense under the Yaklovich standard is claims against me and my law firm, period. Anything, defendants, clients against third parties that I had no control over or no representation of are clearly outside the proceedings. I would also say, so aside from that factual error, the legal error is that the standard for abusive process does not require the outside of proceedings element that the trial court imposed in this particular case. With that, I would urge the court to reverse and remand for further proceedings. Thank you.
You'll have about 2 minutes for your rebuttal.
Thank you.
May I proceed?
Yes, please.
Thank you. May it please the court, opposing counsel, my name is Carol Tran, and I have the privilege of representing the estate of Stanley Aronson in today's proceedings. The issue that we're here to decide is, has there been a perversion of the legal process in the underlying proceedings to accomplish an ulterior motive for which it was not designed? And I respectfully submit that the trial court got that answer right when they answered that question in the negative. One of the things that's important to keep in mind as we're analyzing this particular case is the claim that's before the court. The only claim that we're here to consider is an abuse of process. It is different and apart from related claims, for example, malicious prosecution, frivolous conduct under Civil Rule 11, or Ohio Revised Code 2323.51. And the reason I bring up these alternative claims is that that's not what we're here to talk about today. While some of these allegations may potentially fall into a claim of malicious prosecution or frivolous conduct, it does not fit the mold of abusive process. When I think of something such as abusive process, I think of things such as issuing a writ of execution when a judgment has been stayed to freeze someone's bank accounts to harass them. When I think of abusive process, I think of something like issuing multiple subpoenas against a witness that has nothing to do with the case, so that they have to appear for a deposition to harass them.
Isn't keeping someone involved in a lawsuit, could be harassment?
In this case, our position is that continuing a lawsuit in and of itself is not enough to constitute an abusive process. That was the standard that was set forth by the Ohio Supreme Court in the App.No case.
But if continuing then into a lawsuit to try to get a settlement with another party in another matter, wouldn't that constitute potential abusive process or harassment?
The case law is clear that simply continuing a lawsuit, even if you have, for example, ill will or bad faith, is not enough. So there's multiple cases that talk about simply continuing a case is not enough. There has to be some perversion of a process within the proceeding for there to be an abusive process. So there's a couple points in time that we need to make sure that I believe that needs to be delineated. The first is instituting the lawsuit. There's multiple cases that say simply initiating a lawsuit is not enough to constitute an abusive process. Even if it's for the purpose of embarrassment or humiliation, that's the case of Kramer versus Cox out of the 9th District. Even if you had bad intentions, such as getting someone fired as a result of a criminal conviction, that's the Cox versus Oliver case out of the 2nd District. Even if the other side thinks that you are launching a smear campaign, that's the Moore versus Feldman case out of the Southern District of Ohio. Even if they believe it's retribution because the other side complained to law enforcement, that's Bex versus Geis out of the Northern District of Ohio. There has to be a perversion of the legal process. So the mere fact that you institute a lawsuit is not enough. But after that point, continuing to maintain a lawsuit to its authorized conclusion. This is a quote from the App.No case from the Ohio Supreme Court. Continuing to maintain a lawsuit, even if you have bad intentions, that's not enough. And I think multiple of the allegations I have brought up by opposing counsel fall into this category. So the idea that Attorney Aronson continued the lawsuit after he withdrew as counsel. The App.No case has already addressed that issue. The fact that Attorney Aronson continued the lawsuit after receiving certain legal memorandums from his clerk suggesting that some of his claims might not have a lot of merit. You know, the idea that he continued the lawsuit to defend his daughter's honor or to rehabilitate her reputation. There are procedural mechanisms in every case to dispose of claims if you feel that they're not meritorious. You can file motions to dismiss, you can file motions for summary judgment. There are procedural mechanisms that account for that sort of issue. But just because you continue the lawsuit is not enough. And keep in mind that ultimately, all of these cases against opposing counsel were dismissed without opposing counsel having to contribute anything towards the settlement. The idea that it was somehow improper for Attorney Aronson to approach opposing counsel to ask if he could assist in obtaining a waiver or discount of monthly maintenance or conversion fees, that's what the entire case was about. We can't look at the claims that were brought by Attorney Aronson against opposing counsel in a vacuum. What led to those claims was the fact that there were multiple collection actions, particularly there were 4 collection actions that were brought against Attorney Aronson's clients. And it was stemming out of those lawsuits that there were counterclaims and third-party complaints that were filed. I would submit to this court that it is perfectly reasonable for someone to approach former counsel for the Housing Corporation, someone that Attorney Aronson had believed was the mastermind in orchestrating the conversion to the condominium, to see if he'd be able to knock off a couple dollars. This is part of normal settlement negotiations that happen every single day when there's multiple parties, multiple claims, and you're trying to reach a global resolution. A settlement agreement doesn't have to depend upon the merits of the underlying claim. You know, take for example, an instance where an injured party in a motor vehicle accident decides to bring a bodily injury claim. And we get to the mediation and they say to the defendant, I want you to throw in a couple extra bucks because my car was totaled. Well, the court would never be able to authorize an award of property damage for a bodily injury claim if this went to trial for a claim that was never put before the court. But this is something that is discussed when people are trying to reach a global resolution.
Isn't what you're talking about a question of fact here, though? Whether these were normal settlement negotiations or whether there was an alternative purpose, a purpose that wasn't legal or abusive process. Isn't this we're at summary judgment here. Shouldn't a jury be deciding whether these interactions constitute an abusive process?
I believe no, because I think the part that's missing is what was the legal process that was abused. Okay, there's a lot of focus on what his secondary objectives were behind the scenes. Okay, but what was the process? There was no, for example, was there a writ of execution? Was he noticing opposing counsel's deposition? Was he, attaching property? There wasn't a separate legal process. The only thing that happened was he was continuing to maintain the lawsuit. So, and that's the issue that the trial court came upon, is that there hasn't been a specific legal process that has been identified that was abused. Outside from the overarching fact that I don't believe that you should have continued filing the suit against me because I don't believe you have merit, that the claims have merit, that's not enough. This isn't a malicious prosecution case. What is the process that was abused? And settlement talks between lawyers, that's not an abusive process. And in fact, I would submit that statements made by counsel are privileged and cannot be used to support a tort claim. And that's out of this district, the Willis versus Lennon case. Ultimately, the release that was obtained in the underlying suits was exactly what Attorney Aronson had approached opposing counsel in an attempt to achieve, which was a reduction in the fees. And opposing counsel enjoyed the benefits of that release when he was dismissed from the case and did not have to contribute anything towards the settlement. If your honors do not have any other questions, I'm ready to conclude. Okay, so the trial court granted summary judgment in favor of Stanley Aronson, and I ask that this court affirm the trial court's decision. Thank you.
Thank you. Counsel, you'll have 1 minute, 52 seconds.
Yes, Your Honor, very, very briefly, in reverse order. Release does not apply to me. I didn't know it existed. I didn't represent the client. I didn't get consideration. I didn't get any benefit from it. The case law cited in the brief, it does not apply. The Willis-Lennon case applies to defamation cases. I would say that in court proceedings, if you have a defamation case, those communications, spoken words are protected. Let's go to the core issue, and that is the abusive process and the perversion of the process. There were no normal settlement negotiations in this abusive process claim where the defendant, Mr. Aronson, came to me and said, I will negotiate with you to resolve the claims against you. It wasn't even a question of, in connection with the negotiations with you, there were no negotiations with me. There was no effort to settle anything with me. It was always through you to your former client and third parties. And the leverage, the ulterior purpose is not just will you have this conversation with me. The abusive process is the leverage, the club, to quote from the Robb case. I will dismiss you I will stop suing you if you get this benefit for me. That's the leverage, that's the difference. In the context of a lawsuit where you're at a pretrial or a mediation and somebody says, hey, can you work with the other side to get a settlement package together, something like that, that was not the issue here, that's not what happened in this case. And I guess I would say that you have to look at the process itself, and again, although the defendant's not arguing it here, in the trial court relied on the inside-outside, and I think that standard simply just does not apply. Other than that, I don't think there's anything else that requires rebuttal unless the court has questions for me.
Hearing none, thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk, of course, will mail a copy of the decision to you on the day that it is released, and they will also be posted on